All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us for Supporting Youth at 18, Understanding Decision-Making Options. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of the recording and the materials and the CLE code via email from Zoom within about 24 hours or so. You will also be able to find it on our YouTube channel. We also have a designated page where we're storing all of the links for the recent trainings for this series, and you can also find the links to the upcoming trainings for these series if you want to register ahead of time. This training was approved by the Florida Bar for 2 General CLE credits and 2 Juvenile Law Certification credits. I will drop the CLE code in the chat towards the end of the webinar. That CLE code will also be included in the email that goes out from Zoom, and you can also find it in the YouTube description. If you need a certificate of completion, please email me after the webinar is done, but I will be out for a few days after this webinar, so I will probably respond with the certificate by next week. The closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or captions, you can reach out to me directly. I mentioned the certificates already. So for questions, you will notice that we have the Q&A feature on Zoom. You can click on it and you can ask questions there. If we may be able to answer them directly. If for whatever reason we can't answer the question in the Q&A directly, we will wait until the end and address those towards the end. So this training is being co-hosted by PILS. If you don't know what PILS is, it's a public interest law section of the Florida Bar. So I'm going to be dropping that link for PILS into our chat as well, and I will include a bunch of information about PILS in the material. So before we introduce our speaker, I'm going to pass it over to Robin Rosenberg with Florida Children's First. Robin, the floor is yours.
Thank you very much. And Erica, you'll put the next slide on, please. Well, welcome everyone to, I don't even know what number we're at in our training series, but Florida's Children First has a monthly training series, third Wednesday of every month, on topics that are of interest to attorneys and judges and guardians ad litem and other folks who are involved in Florida's child welfare system. Florida's Children First does this as part of our work and our commitment to providing all children in state care with high quality legal advocacy. And the more the lawyers, JALs, judges know about what children's rights are and how to effectuate them, the better off the children and their parents are going to be in the child welfare system. So this is one of the things that we do to support attorneys. In a second, I'll show you another one of our major endeavors in supporting attorneys. But we are available both to take, thanks Erica for flipping it over. We run the Florida Dependency Law Center, which is a free resource for attorneys and judges who work with young people in the child welfare system. There's a ton of resources and communication tools on the website. Possibly you learned about this training from an email that went out to the registered users. There's over 1,000 of them in Florida who participate in the website. It is free for lawyers who are in good standing, lawyers and judges with the Florida Bar. Erica, if you could go back to the previous slide, though. What we do at Florida's Children First is multifaceted. So training and supporting attorneys is one chunk of the work we do, providing direct legal representation with awesome attorneys like Erica and her colleagues who are around the state. But that's just a piece of what we do. Florida's Children First for over almost 25 years has been an advocacy organization advocating for systemic improvements to Florida's child welfare system. A major way we do that is by being the organization that houses and supports our affiliate, Florida Youth Shine, which is an organization of current and former foster youth in, I think it's now 14 or 15 chapters around the state of Florida, who are currently or were recently in the Florida's child welfare system. So we at Florida's Children First learn from them, and we support them in their own efforts to do advocacy to improve the lives for themselves and for their peers and those who will follow behind them in care. So we do that directly with Florida Youth Shine. We also publish a lot of educational materials that are available on the Florida's Children First website and are published through Florida Youth Shine. and are free educational materials about aspects of the law and the system that will help young people have a better future. So that's a little bit about Florida's Children First. I am very excited to turn it over to my colleague Ericka.Herring to dive into our topic today. Thank you, Ericka.
Thanks a lot, Robin. Appreciate it. All right, so I've got good news for the group, and I've got bad news for the group. The good news is, that we've got Beth's amazing materials for today's presentation, and I will not be able to do her justice. She is an amazing speaker, presenter, but unfortunately, she was unable to join us at the last minute. So you've got me. Here's some information about my background. Needless to say, I've done a lot of work in the child welfare space for years. And I've spent a lot of time working with families and children that have developmental disabilities, which is sort of where the guardianship aspect of my work came in. So, but before we dive into that, we want to talk a little bit about the legal needs of children, which is the Florida Bar Committee, because this is the group, a group that, works together across the state, and I've got their mission here for you to review. They came to us and asked us if we would present on this topic because it is such a huge topic. It's such a huge need across the state, and not just for children who are part of the child welfare system, but just children in general. And so, and even adults. And we'll talk about that. So they asked us if we would please, sphere this training, which of course we're doing. And so we want to make sure to take a moment to show you, and we will have a link at the end of the presentation for the handouts and resources that will link you directly to the Legal Needs of Children Committee. So you can see right at the top of this, it's got their mission, and it also has presentation CLEs for you to look at. And then if you scroll down on that page, and I apologize for not showing this live, but sometimes when you try to do this stuff live, it doesn't work as well. This shows you all the different types of resources currently available, including a list of legal aid offices that assist with guardianship and guardian advocate and supportive decision making, which we're going to talk about all three today. Florida Wings, the lowdown on the law. It's really good information. So I encourage everyone to please take a look at it at the end of this presentation or whenever you have time. Now, here's our agenda for today. It is a lot of material, friends. I'm going to do my best to go through it, be lively, and answer questions as they come about. And hopefully you will learn a lot from today. And if not, hopefully you will either ask us questions that I will get back to you on, or you will be able to do some research through all of the resources we're offering today. So we're going to talk about Regis Little staffing. Okay, this is where it kind of all starts. We are going to talk about both the guardianship and the guardian advocate process, about what it is, what the general process is. And then we're also going to discuss other least restrictive options, and we'll get to that. And it says questions and wrap up at the end. I'm hoping we'll be able to take breaks here and there, and I'll be able to answer questions live, and I might chime in and ask Robin or Jorge if there are any questions, because I am going to be honest with you, I'm not looking at the chat so I can focus on the presentation. So let's talk a little bit about Regis Little, and I want to apologize in advance if you've not heard of this, but it is an extremely tragic story from my local area. I am located in Seminole County, Florida, and I was living in Orange County at the time that this occurred. So Reggie was 18 and found stabbed to death in a parking lot. Reggie had an IQ of 65, as it says here, bipolar, hyperactive, was taking a lot of psychotropic meds, had been in the system for a long time. He kept turning down help. He said nope when the CDC offered him help. Agency for Persons with Disabilities said, offered assistance. He said no. And the truth is, if we had what we have now in place, would the outcome have been different? We don't know. We'll never know. But other kids now have a chance, a different system, a different approach. I hate to say thanks to Regis Little, but it is called the Regis Little Act. So I'm going to gloss over exactly all of the actual textual language for the Regis Little Act. I am providing it as a handout in case those of you that want to see kind of the history and sort of see, where it all came about. But these are the different statutes under Florida law where you will see things that came out of the Regis Little Act. It made updates to the law, such as Chapter 39. We've got these two, these three actually. Keep going. And then we've got Besides Chapter 39, Chapter 393, which is the chapter for developmental disabilities, this is where you'll find definition for developmental disability. You'll find this. And then we've got Chapter 744 for guardianship. Okay, so we're going to go ahead and dive in and start asking some questions, right? Because the overall, and I've got it in a slide coming up, so I should have probably put it here, but the whole point of the Regis Little Act was to create guardrails, was to start trying to figure out who could provide guardianship or guardian-like assistance. I don't want to call it necessarily guardianship, but who could provide assistance to this young man to help him make decisions so that he would not have been homeless and ended up in the situation that he was in. So we're going to talk about a couple cases. I call them cases. These are actually kids. These are kids I worked with. So I know these kids really well, and we're going to have some polls. So get ready to answer those questions. So first, we're going to talk about Mandy. Mandy's my girl. Mandy has cerebral palsy. She uses a wheelchair for long distances. For shorter distances, she uses a walker or even arm braces. Also, she has a shunt in her brain. She needs help using the restroom. So at school, she actually had a nurse that would come and use a catheter, I think twice a day. She's decided she wants to drive one day, but she'll need the car adjusted for her to control the speed through her hands. Mandy, I need to fix that. I shouldn't say many, is a bright young lady and has a normal IQ. So keep Mandy in mind for just a second. Now we're going to talk about David. David is turning 18 this summer. He lives in an APD group home and has for about 2 years. He has autism and needs supervision to stay safe, but can make some decisions for himself. He's still going to school and likely will until he's 22. He loves playing video games, but getting him to tidy up his room is difficult, right? Non-preferred tasks are not his thing. He needs reminders to do things like take a shower or bath and take his medication. He sometimes has anger outbursts and has attempted to elope a few times, but it's been happening less as he becomes adjusted, right? Transitions have been extremely hard for David. So, first poll of the day. Does Mandy need a Regis Little staffing? Yes, no, unsure. Do you think David needs a Regis Little staffing? Yes, no, unsure. I'll let you tell me, Jorge, when we can.
Where answers are coming in. We're at
No
about
worries.
44% participation. Let's give them a few more seconds.
No worries. We're good.
All right, we have about, we're close to 60 out of 100, so I'm gonna close it out in 5, 4, 3, 2, 1, and ending the poll. Let's share those results.
Awesome. Let's see, folks. Okay, so we have 48% of you think that Mandy needed a Regis Little staffing. 30% said no for Mandy, unsure 23%. And then for David, 72% of you said yes, he did need a Regis Little staffing. 2% said no, and unsure was 26%. So I'm going to tell you how this actually played out. Mandy did not need a Regis Little staffing. Mandy is fully capable of making her own decisions. So she did not have uh, a Regis Little staffing. She did have a transition staffing. She still needed transition services, right? Like all kids, all youth do. I shouldn't say kids, youth. All youth do. But Mandy didn't need one in any way, shape, or form. So, but David did. David did absolutely have a Regis Little staffing. And we followed that entire process for him. But Mandy did not need one. David absolutely needed one. So here we go. Here's the slide. So what does it all mean? It's really, truly about creating guardrails, okay? By working collaboratively as a team, right? DCF, GAL, AAL, CBC, case manager, supervisor, working together as a team to try to figure out who is a potential guardian and or guardian advocate for the youth when they turn 18. And then once that person is identified, right? Okay, great. We've identified a person, and we'll talk about this because I think you should identify 3, but we'll get there. You want to make sure that all the paperwork and supports are in place so there are no gaps in services when the youth turns 18. So here we go. So before I dive into this is a doc, a living, beautiful doc, PDF that you can pull off of the Florida Law Dependency Center. And specifically, I want to thank our friends at the L. David Shear Children's Law Center of Bay Area Legal Services, because this is a great handout And you'll see why. So here we go. First, we're going to identify youth, right? If you're involved in a case in which the youth has a developmental disability, all right, and we are going to talk about the definition of a developmental disability, excuse me, further down, but it's listed here on the slide for you. Or, here's the or, has another ailment, think TBI, serious mental injury that prevents them from handling their own money or making decisions, and is turning 18, then we want you to take the following steps. So step one is going to be schedule a face-to-face. Do we see face-to-face fold? Yes, we do. It is critically important that we schedule this face-to-face because there's a lot of, as we all know, nonverbal communication that happens. And I find this to be a very critical part of establishing rapport and really trying to figure out how much help a youth needs when we do it face-to-face. And of course, who are we inviting? Please, let's invite everybody that's appropriate, right? There might be maybe there's a parent, maybe a parent is not appropriate, right? That's a case by case basis. If they are, please, let's make sure that everybody is at the table, right? Because at the conclusion of that meeting, we need to have an idea of, well, not have an idea. We need to know who the youth trusts, right? This is going to be a very key person in either being a potential guardian and or helping select one. It's just really key to start with that. Because again, if the youth doesn't trust the person, we're not going to really get far. And we'll keep talking about that. And step two, right? You're going to notify the court at the 17-year-old JR of a potential need for assistance, right? You're going to have to tell the court. And at this point, the youth, if interested, should be attending their hearings so they know as much as possible. And I always like to add this caveat. When I work with kids that have developmental disabilities or any sort of disability, learning disability, right? I do get a lot of extra questions from my clients. I think that's normal. And I think it is my job to just spend that extra time explaining it to them in a way that makes sense. And that's also part of establishing rapport, right? Like I may not know right at the beginning how to discuss these things with them or what analogies to use that'll make sense to them. But obviously over time, that does. Then we would go on to step three, which is request a multidisciplinary report. Okay, and it's going to get, so check this out. It's a report from a licensed psychologist that includes an IQ test, okay, and determination about whether the youth can make decisions related to, and here's all the list, right? A psychosocial and educational report, an IEP that it's not older than 2 years, older than 2 years, can be used in place of the report if they contain an IQ test and a review of what tasks they may or may not be able to use, right? So this might come into play. You might have to be thinking really far ahead of when the reevaluation process is for the IEP. When is that due? To see if at that time it would be appropriate to get that testing so it's within the 2 years, so you don't have to do the MDT report, which is still possible, but it might just be easier to get it done through the school system. Then we'd move on to step 4, which is review the report to help determine which level of assistance, if any, again, I bolded that, the child might need. We'll talk about that also in a second. And here are 3 options, right? For the type of relationship this person can have with the youth. So we're talking secured adult connection, which I will call supported decision making, which we will discuss later on, guardian advocate, and guardian. Then step 5, if the team determines the youth is in need of a guardian advocate or guardian, here's where it says select one or more adults to submit to the court. I highly suggest having at least 3 names. And then why would I say 3 names? Because I always feel like right before our youth are turning 18, I feel like there's a lot of moving parts, right? Just in general, but a lot of like getting nervous about if they have to move, if they don't have to move, our school's going to change. There's just a lot of intensity. I call it intensity during this time. And so I think that there might be just some shifts, right, in relationships and people. So you should always have 3. Notify the court and attorney for the state. Ask the department to file a petition for guardianship. If they are unable to, find out if the local legal aid program is willing to do it. Does the guardian have access to attorney resources, the potential guardian, see if that works. And then we're back to David, okay? So we already talked a little bit about David, and I thought now that we've looked at the context of the Regis Little staffing and we know that he had a Regis Little staffing, question, we're going to launch a poll now. What additional information would be most helpful to know in determining what level of assistance you might need? Now, I'm going to let you guys know there is no wrong answer here. But I'm curious to see what people think is the most important out of all of these. And I would personally take all of these into account, but I'm curious to see what people think is the most important.
While the poll is coming in, Erica, there was a question as to whether video conference suffices for face-to-face.
I I would not. I would say no, but I understand there can be locations in Florida, right? Like in certain parts of Florida, if like the youth is in one part and the team is in another part, I would really, really, truly strive to do the face-to-face. I don't know, Robin, if you have a different idea, but I believe face-to-face is very clear. Um, Even under Medicaid standards, there are certain things that they require to be face to face. So I believe it should be face to face. How are we doing with the poll, Jorge?
Let's see. Answers are coming in, and we're at 67 out of
Oh,
104, and a few more just came in. So I'm gonna go ahead and end it in 5, 4, 3, 2, 1, and we got to 70. So sharing the results.
awesome. Ooh, love it. 31% of you said, can he manage money, small amounts, picked it. Can he take public transportation? 3%. Can he cook or prepare meals? 10%. Does he know what to do in an emergency? 56%. So that's where I was leaning. I was leaning towards if, the youth doesn't know what to do in an emergency, doesn't know calling 911, doesn't like any of that sort of thing, that would cause me some big concern. But these are other things, right? Like the cooking or preparing meals. I did have a client who, I hate to say, burned down a kitchen at a group home, but he did because he did not know how to cook with grease and was not being supervised. And I think the public transportation, obviously, if a person cannot, I think public transportation can be difficult for lots of people, not just people, individuals with a developmental disability, but like David has, and the managing money, even small amounts, I think of that. I take that into consideration as well. So, and then now we're going to talk about Christy. So, and this is one of my actual, I shouldn't call her kid, but she's a kid. Christy will be 18 soon, but she's not worried about what will happen to her as an adult. Christy has been diagnosed with autism, an intellectual disability, and cerebral palsy. And friends, yes, all three she was diagnosed with. She currently lives in a nursing home, and we'll talk about that also. In the children's wing, where they plan to keep her even after she turns 18, since she functions at about a 12-month level. When we are together, I read her books and we play peekaboo. She's very happy and loves to have visitors. She attends public school. She hasn't developed many language skills yet and is completely dependent on staff at the nursing home to take care of her. And yes, I understand we don't hopefully have children in nursing homes, but she was many years ago, she was in a nursing home. So what type of assistance would you recommend putting in place for Christy? And here we got our poll.
I'm about to launch it. Sorry, I have to back out
No
of
worries.
the other one.
It's okay. No worries.
Erica, while the poll is launching, if you can open up the Q&A and see if there are any of them that are you able to
Sure.
do that?
Let's see if I can do that.
And I'm not sure if you can answer them now or you plan to talk about them.
Let's see. Oh, I see a question about APD. I can get back to you. I can get with you, Mr. Turkett, on that one. And I am trying to, what if we have no one willing to be the guardian or guardian advocate for a child? My understanding. So we will talk about the public guardian program a little further down. What if the young person says they don't want a guardian or a guardian advocate? Well, we'll talk about that process as well. They will be represented by counsel. So we were going to discuss that further down. We're going to discuss venue. Um, We will discuss venue. The statute says venue for a guardian advocacy is where the youth lives or where the dependency case is. Our chief judge refuses to handle cases where the youth is outside of our circuit. I believe it is based on where the child is, the dependency case is. So I would love to talk to you separately after this. And I apologize. Are we done with the poll? Just because I scrolled through and
Yeah,
then I
well,
made the poll
I haven't
disappear.
ended it. I was leaving
Oh,
it
gotcha.
just in case, but yeah, it's 65 people answered, so I'm gonna go ahead and end it right now and sharing the results.
And thanks, Robin, for showing that. I will make sure I'll scroll through again at the end in case I didn't answer any of these. All right, so we're talking about guardianship plenary or limited 55%, 28% guardian advocate, supported decision making 17%. So this is the only youth I've ever worked with in my career, and I've been practicing, I don't know, like 17 years, that the public guardian program actually took her. And here was their reasoning for it. And we will talk a little bit more about the public guardian later on, but they took it, honestly, it was just for two reasons. Number one, they took it because she was in a nursing home and they were not concerned about her eloping. They weren't. The second reason they took her is because based on her medical condition, they didn't expect her to live a very long time. And she probably lived an additional 2 years after she had the public guardian appointed to her. But that is the only time I have ever had the public guardian program actually take a youth that I was working with. So now we're going to start getting into the guardianship, guardian advocate, but I did want to show this beautiful upside down triangle, thanks to our friends at Disability Rights Florida, right? Because we're going to start with guardianships. We're actually going to start at the bottom, which is the least amount of rights, and we're going to work our way up to supported decision making, which is more rights. But I did want to show this, and I'll show this again one more time, about the guardianship, right? Because we're about to dive into this, but I really think this is a great graphic. So this is Beth's work again. I am sorry she is not here. This is great stuff. So we are going to talk about guardianship and guardian advocate, and they're very similar, and yet they are not. So we're going to go through the guardianship piece first, and then we'll talk about guardian advocate and keep on going. So this is what we're going to talk about. We're going to talk about defining guardianship, explaining the general process, reviewing timelines, and then discussing guardianship administration. Now, I may go a tad fast on some of these slides. The information is still here, but I really want to spend a good chunk of our time on the guardian advocate because that's what we are seeing more often with our clients in child welfare. So guardianship is a court process. So it's determining someone's legal capacity. Are they able to make decisions on their own? And if they're not, the court is going to remove those rights from them and delegate it to someone else. Okay. And the court also has ongoing oversight of the guardian's exercise of delegated authority. And so it's kind of in a nutshell. It's a court process. And I think this is extremely difficult for especially parents when their children turn 18 and they're like, what do you mean I can't do X, Y, and Z? So, all right, and here's the general process. So when we're talking about a guardianship, which again can be what we call plenary. Plenary means the person is retained zero rights. They don't have any rights in any fashion. If they retain even one right, so I typically see clients get to retain the right to vote, then it's not considered a plenary guardianship. It's considered a limited guardianship. So for the general process of an actual guardianship proceeding, there's actually two things going on. There's the incapacity proceedings, which is the process towards the left, and the guardianship proceeding, right? Where so for incapacity, the court, a petition is filed, the person that's going to be the guardian files the petition and says, we think this person needs help. The court appoints a 3-person examining committee. We'll talk about them. The person who, what they call the alleged ward, the incapacitated person, is appointed an attorney. And please note, it's not a best interest standard. It is direct representation. And then the examining committee reviews, the examining committee evaluates the person, submits the paperwork, and then there's a hearing. And then, as you can see on the right, for the guardianship proceedings, the interested person will file a petition, application, and oath. There's a level 2 background check. We're going to talk a little more about that. Also, credit report has to be provided, and then the court has a hearing. This just talks a little bit about who the examining committee is, right? The court is going to appoint this examining committee. And here kind of a list for you who is actually a part of that committee. Now, what is it? So check this out. The evaluation typically only lasts 15 to 30 minutes and consists of observations and interviews and a physical examination. Now, where? Could be in person. It could be conducted by phone. I'm sorry, in person or maybe conducted by video with court approval. And it could be that they come to the person or the person comes to them. So this examining committee must be appointed within 5 days after the petition is filed, and they must file written reports within 15 days. Now, I'm going to tell you, that's in a perfect world, and we'll get to that as well. So this is going to be considered evidence to the court as to what the person's alleged incapacity is. Okay, so they're going to submit their report, and the court's going to use it as part of the evidence for the hearing to determine if the person is in fact incapacitated and does need a guardian. So here are the rights under 744-3215. These are all the rights that are removable. See, marry, vote. See all the stuff on the left? Okay, great. So that's all the stuff that can be removed. And then on the right are all the delegable rights. So in other words, those are rights, all removed rights are delegable except so things like contracts, sue and defend lawsuits, manage property, all those things are delegable. But what are the retained rights? See, I love this, right? They're represented by counsel, to be present at hearings, to a qualified guardian, to have access to courts. Here's kind of the list of all the rights that they do retain, even if they have a full guardianship or a limited guardianship, they still get to retain their rights. So who can be a guardian? Okay, in Florida, it could either be an adult resident, so that's what that means, or a non-resident if they're related to the person by blood or spouse of any of the person. And there's a list of like relatives, like, you know, siblings and parents and aunts and uncles, and under the chapter there's a list. And so that person does not have to be a resident of Florida. But who cannot be a guardian? People who are felons, physically or mentally unable to fulfill their duties, persons convicted of child abuse, neglect, or abandonment, and persons judicially determined to be guilty of certain crimes or even a conflict of interest. So I think the conflict of interest is if the child's the person lives in an APD group home, the APD group home owner or any staff member cannot become the guardian for that person, for example. And so what is the guardian? And we talked about this a little bit, but here's kind of another way to think about it. They're the decision maker. They're defined by the court to make personal, financial, or legal decisions. And it's whatever rights the court delegates to them is what they can do. Okay. So here we go. Here was the venue question. So this is for guardianship. And also for guardian advocate. So for incapacity proceedings, you're going to file in the county where the person resides or is found. For guardianship proceedings, file in the court where the person resides or is found. So it's the same thing for the two, because there's technically two different processes kind of running parallel at the same time. Exception for minors or young adults subject to Chapter 39 proceedings, file in the county having jurisdiction of the dependency court. That's the answer to one of the questions. And so again, if you need to talk to us offline, please reach out separately. I'd love to chat with you. Here we go. So this is one of the big changes from the Regis Little Act. The court will take jurisdiction when the minor is 17 and a half and the letters, right? So this is what they call the letters. Once the guardianship is established, the person gets letters, and these are the letters that they're able to provide to other providers to say, hey, I'm in charge of making these decisions. Please reach out to me. And so it's 17 and a half, and then will issue upon the incapacitated person's 18th birthday or as soon as thereafter. This is one of the big changes from the Regis Little Act. So here we go, parents. Here we go. This is what my parents do not like for me to tell them. Now, once you turn 18, nobody can make legal, financial, or medical decisions unless they are conferred from someone else. Okay? And the court will appoint a guardian even over, I believe, the objection of the person if it is determined that they're in need of that type of assistance. So types of guardians. Okay, so we've got the public guardian, which is for indigent persons. And it is supported by state funding, and they will typically only serve as guardian of the person. So in other words, there is guardianship over the person and guardianship over the property, which is in the right-hand column. So we'll get to that in just a second. So that's the public guardian. Again, I've only had one instance where the public guardian program took a youth that I worked with. They have always typically declined due to, they don't have space, attrition needed, folks that are eloping, that sort of thing. Professional guardians are, as it says, this is their job. They are, paid to be guardians. And they're approved by the Department of Elder Affairs and register in the county where they are appointed, and they're paid upon court approval, right? So the court determines the payment. I'm sure they submit, paperwork for it, and then the court approves the payment from the assets of the ward. And then non-professional guardians is everybody else, right? Private individuals. It doesn't have to be family, but it can't be family. It's those interested in the well-being of the person. So for guardianship of the person, it's just over the person. In other words, they don't have assets, property, anything besides Social Security income. Social Security, if the person, the alleged ward, only has Social Security income, it is going to be a guardianship of the person. If they have property, like they inherited a piece of property, anything like that, it becomes guardian of the person and guardian of the property. And then a plenary guardian is, all delegable rights that have been delegated to the guardian, and then limited is what has been limited. So for example, again, I typically see that folks get to keep the right to vote. And so that means it is a limited guardianship versus a plenary one. Here are the guardian's duties. So this is this is kind of like a post guardianship to-do list, right? They have to take an 8-hour guardian education course within the first 4 months after their appointment. They need to do the initial care plan. So this is sort of if you haven't seen one before, it's sort of like, this is the doctor, the medication they're on. This is how they're part of their community. They have fun, social outings this way, that sort of thing. And a verified income, the inventory of income and assets when there is property involved within first 60 days after appointment. And then you will do the annual plans for either the person, and then if it's a property as well, guardian of property, you're going to do an annual plan and an annual accounting. Okay. And you must be represented by counsel. This is a really, really, really hard one. And we're going to talk about that in just a second. It's a really hard one for folks because you must be represented by counsel. Must keep the court updated and must obtain prior court approvals for some acts. So the big example that I have is for that youth that I worked with that had the public guardian. She was extremely ill. She ended up being on life support, and that public guardian program had to get court permission from the court in order to take the step to discontinue her treatment, for example. That's kind of one of the things that I know you have to go back to court. There will be some medical procedures that have to be approved by the court rather than the guardian having the ability to do that. So this, friends, is what I call the best case scenario. If the timelines are followed, I'm going to tell you, I have seen this take a lot longer. So attorney information gathering, drafting, obtaining signatures, and filing, we'll give it 2 weeks. That's great. That's something that we can control, right? Entry of orders appointing the examining committee and the attorney. 5 days after the petitions are filed, I typically do see this happening this quickly. The examining committee evaluations within 20 days after appointment. I have not traditionally seen this happen a lot within 20 days. I could be wrong. It could just be my neck of the woods, but I have seen this take longer. The hearing 2 to 6 weeks after the examining report, committee report is filed, depending on court and attorney availability. I think that sounds about reasonable. The duration of guardianship, it's until the ward passes away and then some, right? Because all the things have to be wrapped up afterwards, or is judicially determined to have regained capacity. And then obtaining court approval for certain things, that could be 1 to 6 weeks. I can tell you on a recent case that I was assisting on, the parent had filed for full guardianship of their adult child, and the court basically told them to expect it to take 3 to 6 months to complete the process. This person was trying to get an emergency guardianship. They were issued emergency letters by the court, but basically were told, this is going to take a lot longer than you think. Just keep that in mind. All right, so what to expect? So here are kind of the big things. Courts must consider less restrictive alternatives before appointing a guardian. And I think this is a great time to talk about that. We want folks to be able to be free and make their own decisions. If they're able to make their own decisions, there is no need for a guardianship. This isn't we don't like the decisions they're making, so we need to put this in place. That's not what this is for. This is truly for someone who lacks the ability to make decisions and or needs help. And they may not need a guardianship or a guardian advocate. They may need a supported adult decision-making agreement. And we're going to talk about that. So expenses. filing fees for initial petitions and annual reports, attorney's fees, guardians attorneys, and the examining committee members' fees. It is not cheap, friends. It can be thousands of dollars. So the guardianship process is not cheap, especially considering that the guardian has to be represented by counsel. So there's a lot of paperwork. Requests for authorizations will require a lot of paperwork to be submitted to the court. And frustration. Did you see that little frustration icon? Yep. Most case milestones take longer than expected. Like nothing, right? It's part of the judicial system. It's going to take time. The courts are backlogged. And organization, this is just a tip. It's a must. All records must be kept for a minimum of 5 years. It's incredibly important. Before I shift really quickly into guardian advocate, I don't know if there are any questions I can answer right now.
There are a few in the Q&A, a new one that came in about guardian of
I
property.
marked one of them as answered. There are still two, the one about APD, and the one about not having a willing guardian or guardian advocate for a child. There's one new one that came in, which I can read it out loud. We have
If you
had
don't
quite a
mind,
few
go
probate,
for it.
yeah. So the question is, we have had quite a few probate cases lately where we have needed to get a guardian or a guardian of property appointed in order to move forward with the probate, and it is very difficult to get attorneys to do the guardianship pro bono. Are there any resources available from the state that you know of?
I am not aware of any. Um, I am not aware of any. I apologize. I do not. I'm going to keep thinking on it. And please feel free to reach out to me after the training because I will continue to. This is just an area that is near and dear to my heart, obviously. But I do believe that that is a huge issue across the state is where are we going to find the guardians? Where are the guardians? Where are the guardians? So I
And
will keep plugging along. Sorry, go ahead, Robin.
I will just pipe up that this is definitely an issue of concern that the legal aid organizations are looking at and looking to see if there could be changes to the rules, because one of the things that keeps legal aid programs from acting in that role is the requirement that once you're in, you can never get out. And so that makes it really challenging for them to accept cases. So there's some possible advocacy on probate rule changes that might make it easier to get people to take either to get people to take them pro bono or for legal aid programs to do them. But it will require some rule changes or statutory changes.
And I would actually say, Robin, that this is why I think even pro bono attorneys are reluctant to take these cases because you are on the hook. So if the person is 18 years old, they may outlive you. They could very well outlive you. And so it is almost could be a career-long commitment if you take on a pro bono and the person turns 18. So I've been offered that feedback about like, well, I don't, I'll do the initial paperwork, but I really don't want to have to do this annual accounting every year, that sort of thing. So now we're going to flip to guardian advocacy, right? So when you were remembering that upside down triangle, guardian advocate is part of that process. And so we're going to go ahead, talk about the same things again. I'm going to talk about it a little bit differently now that we've got kind of the base for the guardianship. The guardian advocate process was created. It is a more recent process in Florida, and it was created and contemplated specifically for families with children or other close relatives that have developmental disabilities, and you're going to see why. Created by the legislature to be largely a pro se process, so that requirement under guardianship that you must be represented by an attorney is not required if it's for guardian advocate of the person. Now, if it is guardian advocate of the person and property, yes, you are required because of that property piece to get an attorney. But again, as long as they're only receiving Social Security benefits, the guardian advocate of the person process is all that you'll need. Some counties have forms that like Adobe fill in, and pretty much you just answer the questions and there's a link for you to, there's actually a great link that shows you which circuits have forms and which do not. And pro tip, I have taken forms from other circuits, edit them for the circuit I was going to file them in and use those. So that's also another option if you'd like. Don't have to, but it's just an idea. So the difference with guardian advocacy, it's again, it is sort of the same concept. It's a judicial process that determines that someone needs assistance with making decisions, and then the person, the guardian, being given specific rights over the ward. So the difference is to be eligible for guardian advocacy, the person has to have a developmental disability and lacks some decision ability making, right? Not everything, but some. Um, and if the person with a DD lacks decision-making ability to do all tasks necessary, guardianship may be more appropriate, right? So this is sort of like the attorney. I know how much we love to not say this. It depends. It depends. It's going to depend on a case-by-case basis on whether the person really needs a guardianship and or guardian advocate. But if I have to pick between the two, I would always go for guardian advocate if it's in any realm of possibility, because the person gets to retain more rights that way. And there's no determination of them being incapacitated. That's not part of the process. So here is the Florida statute definition of what a developmental disability is. Note that in the state of Florida, it must manifest before the age of 18, which is different from Social Security standards, which is 21. But just know that for the definition, so in order to be eligible for a guardian advocate, it must be the Florida definition of a developmental disability. And again, it's sort of the same process, right? The person files a petition, the application, the oath, but guess what? You just have to provide medical records of the developmental disability prior to the person turning 18, right? So there's no examining committee, nothing like that. And then they typically also ask you to include the IEP to show evidence of the person's abilities. And again, because of the Regis Little Act, excuse me, the petition can be filed at age 17 and a half. And here you go. There is an attorney to represent the person, they call them the ward. And that person is discharged. See, in the guardian advocate process, they get discharged after the initial plan is approved. So that's sort of different than the guardianship process, right? And did you see no examining committee is appointed? There are no fees associated with it. You don't have to take the person. None of that is going to happen. The applicant does not need to be represented by an attorney unless the person has assets. So unless the ward that you're looking to be the guardian advocate for has assets, and then you do. And then the hearing must occur as soon as possible. So again, we talked a little bit about it. The forms may be found online in many clerk of court websites. And then some legal aid offices do offer pro bono or discounted representation. So I would tell you to go back to the Legal Needs of Children page to go look at that legal aid link, and that should be very helpful for you in determining if your local program does that. So again, it's a little different here, right? Attorney information gathering, it's going to be 1 week less. Entry of order appointing attorney is typically done immediately. The hearing can be set immediately by the court, right? We're not waiting for that committee. We're not waiting for any of that. And again, it's for the duration of the guardian advocacy is until the person passes away or is able to make their own decisions, as regained decision making. So now we're going to switch gears and do another.
Can I
Another.
stop you real quickly?
Yeah.
There was a question about what happens if an incapacitated person acquires a job after the guardian advocacy is in place. Does that create a situation where they now need to get an attorney involved?
It is possible, right? Because if they have other assets in addition to Social Security, right? When they get to do the annual accounting the next year, they would have to inform the court that, oh, this person's now working and making income. I'd have to check the statute again, but I don't think that there's a carve out for any income, any other income besides Social Security. So I'm going to mark that on my list, but I believe it would shift things because they are making income. So hold on, Social Security plus a job. Okay. All right, so let's talk a little bit about Brian. Brian is 19 years old. He has autism, and his adopted family kicked him out shortly after turning 18. He was homeless for a while, but was recently identified as a former foster youth. So thanks to his whole team, he is receiving PES, graduated from high school, and he's attending a local state college. He's not sure what he's going to get his degree in, but it doesn't really matter right now. He's in general ed. Some classes are harder than others. He is receiving Social Security benefits. He rents a room in a home. He has lots of reminders, so he doesn't forget to take his medication. So I think this is our last poll. For Brian, what type of assistance would you recommend? Let me check. Let me know, Jorge, whenever we're ready.
Yes, I'm waiting. We have 46 out of 100. Let's give them a few more seconds. I'm gonna close it in 5, 4, 3, 2, 1, and I'm ending the poll and
Awesome.
sharing the results.
All right, friends. So 6% said guardianship, 35% said guardian advocate, and my friends who said supported decision making, yes, 57%. That's what we have, and we're going to talk about what he specifically has, but that is what he has. So awesome, 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 awesome. Okay, so we're going to talk about this again a little bit. Who can serve as a guardian advocate? Again, same as the guardianship, same thing. Either a Florida resident, non-Florida resident who's related to the person and cannot have certain things in their background. Retain rights, same thing. Whatever rights the court decides they get to keep, they get to keep. And the guardian advocate will have no decision making over that. So again, this list is the same, right? The list is the same. And it's generally the same as the guardian, as a guardian's duty, right? So guardian advocate duties, pretty much the same as a guardian. Um, Same thing, pretty much. And so now let's shift into the topic you didn't know that you were going to get today, that you're going to sort of get today. The estate planning document. So it's a less restrictive alternatives. So less restrictive alternatives to guardianship and guardian advocacy. So we're going to come back to this real quick, right? So we started at guardianships and we've got the guardian advocacy down there. The representative payee, right, for those of you that don't know, is for someone receiving Social Security benefits and they just need someone else to help them manage the money. We call those the representative payee. And now we're going to start moving our way up towards the supported decision making, with all which ultimately what we want is for everyone to have self-determination, right? But while for us to help get us there, we're going to now go into the supported decision making land. So first things first, legal capacity, okay? And we are going to talk a little bit about a durable power of attorney and a designation of a healthcare surrogate. But pretty much the principal must understand the general nature and effect of the document, right? Must be able to communicate for themselves, name who their agent or surrogate is, and must be willing to sign. If the person is not physically able to sign, they must be able to direct someone else to sign. So just keep this in mind as we start going through these different types of documents. So different documents confer different types of authority. So durable power of attorney confers legal and financial decision-making authority. So the who's who. And I have to tell you, friends, it's made me think of like agency law or whatever that type of law is when you study for the bar. And I kind of shuddered for a minute, but here we are. So we've got the principal, that's the person who is appointing someone to manage their affairs, right? And then the agent, and that's the person that they've named to help them with legal and financial affairs. And then a successor can be one person or additional people to back up in case the initial person is unable or unwilling to serve. Now, here are the highlights. The agency authority, agent's authority can be as broad or as limited as the principal desires. It could include healthcare stuff, and it kind of lists here all the different types of powers that can be conferred. They talk a little bit here about what we call superpowers, which must be separately initialed by the principal, such as creating and funding trust and changing beneficiaries. This is all like really fancy stuff. And then effective immediately after it's signed by the principal, and there is no statutory default decision maker in the absence of this. A guardianship or guardian advocacy would be required. Now, just keep that in mind. There is no statutory default decision making in the absence of this. If you don't have this, you have to pursue a guardianship or guardian advocacy if required. This must be signed by the principal, two adult witnesses, and a notary public. Extremely important. Extremely, extremely important. Now we're going to talk a little bit about the designation of healthcare surrogate, okay, which confers healthcare decision-making authority. And again, we're back to this. Same thing. Person who is being appointed someone to make healthcare decisions for them. And the surrogate, right, and the successor surrogate. Now here are the highlights. Here we go. The principal can choose whether the document goes into effect immediately or after the principal has been determined unable to make informed decisions by their primary care or attending physician. Confers health decision-making authority, also enables the surrogate to receive and request information that's otherwise protected by HIPAA, may include or exclude organ donation, and the surrogate must apply for public benefits for the principal. Now listen to what Beth's side note is. In theory, this power includes authority to access supporting financial statements rarely honored by financial institutions. So keep that in mind. Surrogate must make decisions they believe the principal would have made for themselves. Now keep in mind, it must be signed by the principal and 2 witnesses. Both must be adults. Neither witness may be named as one of the surrogates. At least 1 witness must be neither a spouse nor blood relative, but no notarization is required. Now, this is really key. So what happens in the absence of the DHCS, right? The Florida statute establishes statutory default hierarchy of people who can make healthcare decisions for an incapacitated person or developmentally disabled. So it's legal guardian, spouse, adult child, or the majority of adult children, parent, adult sibling, or the majority of adult siblings, other adult relative, close friend, social worker. Folks, for those of us that work with children who are in child welfare, we need to ensure that they know what will happen if they do not have this and they have not selected someone to make medical decisions for them. If their parent was not, parental rights were not terminated for whatever reason, or, do they want that person making medical decisions for them? They may be totally fine with it. It may be fine. But I think it's really important to have that conversation with them about who is their next of kin at this time, and whether they want that person making decisions, or do they have a trusted person that they would prefer to help make those decisions. So things to consider: both the power of attorney and the healthcare surrogate are fully revocable. Neither document can be used to override the express decisions of the principal. Here, check it out. Except in the case of a healthcare surrogate after the principal has been determined to be incapacitated. It is even less expensive than the guardianship and the guardian advocacy process because it has no court oversight, right? And both documents foster independence by allowing the principal to make decisions about who the decision maker is, the scope of their authority. But there is a greater potential for abuse of authority than with guardianship or guardian advocate due to the lack of oversight, right? Because no one's submitting anything to the court. No one really kind of knows. I don't want to say no one really knows what's going on, but sort of, right? And then now we're going to shift to supported decision making. And so for supported decision making, it is a trusted adult that agrees to assist the person making certain decisions. It can be for things like finding a place to live, reminders to pay bills. It can be in writing and signed by all parties, but doesn't have to be. If it's in writing, it's important to share it with anyone assisting the youth, obviously with the youth's permission. Some organizations may still require release to speak to the supported adult, but this agreement is very helpful. And I found this information straight from Disability Rights Florida. So here is a copy of a blank one I pulled straight from their website. I have to tell you, I have a client currently right now. It's actually Brian. I've got Brian as a client of mine right now. And the first thing he did when him and I had our first meeting was he sent me this agreement and basically told me who is the adult, the supported adult who's working with him. And I think it's a really fascinating agreement in the sense that, check this out: for personal care, making choices about food and clothing, taking care of personal hygiene. So you just mark the X. So, for example, my client checked something about, making choices about where and with whom I live. And like, if they don't want the supported adult, supported decision making to chime in on that, they don't check it. So I have this for my client. I think it is a beautiful document. It has been extremely helpful. The person who's a trusted adult still has to submit, sometimes has to get a release signed by the client, but it's still been really helpful. So making choices about medical care and emergencies. So I was extremely pleased to, this is the first time I've had a client who has one. I was extremely pleased to receive it, discuss it with him and his trusted adult, and I just thought it was a great, just a great thing to have in place. And I will tell you though, for my practice, my practice tip on that, I still occasionally, depending on the topic or the situation, I will still call my client and say, hey, I know your agreement says this kind of information is okay to disclose to this person. Are you still okay with it? So I still think that it's important to have like a regular, touch-in discussion about it, just because I know that things can ebb and flow. And so once in a while, if it's something that I think might be sensitive information, I'll reach out to him first and say, hey, are you okay with me sharing this information? How do you want me to handle this? Because at the end of the day, it is his information, for him to decide who should get and who should not get it. So we are officially at the Q&A part. So that means I'm going to start with the chat probably. And let's see if I still have any questions I haven't
Can you
answered.
start with the Q&A?
Okay, hold on. Where do I find?
You can
Little
find it in the
bottom of
toolbar.
I got it. It's under more. I got it. Sorry about that.
Yep.
All right, here we go. Do you have any specialists in APD? Do you know anyone who could handle appeals on denied APD applications for foster children? I actually do. So that is something that we are available to take a look at. It's on a case-by-case basis, but we are absolutely a resource and would handle some of those cases. As far as how would the representation be financed, typically, if it's not us, there are other programs across the state that might be able to take it. And so there typically is no cost associated with it. Of course, maybe there are a couple of private attorneys that do it, and we could get you those names if you prefer that. But it is something that I've handled those appeals before, so that is something that we're available if that's something you're interested in. If that, and I think I see. What do we do if we have no willing guardian or guardian advocate for a child? Okay, so let's talk about this a little bit. My understanding is public sources of guardians or guardian advocates are usually only for the elderly. I will tell you, I'm sorry. Yeah, I will tell you that when I have reached out to the Guardian public programs across the state, they have told me that the statute only allows them to be full guardians. That's one of the answers that I received. It has been a while since I've done this inquiry with the public guardian programs, but that was the first thing they told me. So they would say, well, like we're, under Florida statute, we are here to do public plenary guardianships only. We're not here for people who are eloping all the time, that sort of thing. So I have to tell you, I would dig really deep. If we have no willing guardian or guardian advocate for the child, I would dig deep. Is there a relative that doesn't live in Florida through Family Finders? Can we use Family Finders to find a relative that maybe lost contact with the youth? Can we look at past teachers? Can we look at, I have seen members of, former like volunteer guardians at Lightem, mentors. Who does this child trust? And is there a person that even if the youth isn't living with them, right? Because sometimes guardians are like, wait, I don't want them to come live with me. They don't have to live with you. You can be the guardian for that person and not live with them, and just be there to help them. So I think it really takes looking at the family. Like I said, Family Finders is probably where I would start, and I would look for families, family members, friends, again, former school teachers. I'd love to think that every single person in the system has a trusted adult. I know that is not always the case, but I am hopeful that there is at least one person who would be available to assist that child. Would a parent petitioning for guardian advocacy where the child receives survivor benefits? Would the parent need to have an attorney? So I believe even survivor benefits, their Social Security benefits, I do not believe that a parent would need to have an attorney because it's only Social Security benefits. It's not, it doesn't say SSI. I'll look at the statute again, but I don't believe it's SSI. I believe it just says Social Security benefits. So I don't believe they'd have to get guardian over the property.
So,
But
Erica, in the chat, one of the participants, thank you very much, Daniel, cited the cited the statute 744.3676. It just moved around. 3678 sub 5, saying that it can be waived if I think that's a statute that's at issue. So, folks can look
gotcha.
at that. Thank you.
Perfect.
You know.
Only pursuing if receiving social. Yep, perfect. Okay, great. Thank you so much. That is helpful. Um, I got that one. Any tips on how to determine what rights an alleged incapacitated person should keep when applying for guardian advocacy? In other words, I know voting is usually retained, but what about getting a job, marrying? I know this each situation will need to be evaluated on a case by case basis, but any rule of thumb. Oh, goodness. I don't actually have a rule of thumb. I think typically I'm trying to remember without getting off of the screen, but I'm trying to remember. I believe I believe I think in the guardian advocate process, and I might be wrong. I could very but well be wrong here, but I feel like the courts typically will take most rights away unless someone, the voting is always, I've always seen the voting stay, but I typically have seen the courts pretty much delegate the rest of them to the person applying to be the guardian advocate. So I guess if you're saying as their attorney, we should be advocating for which rights they should choose, they should keep. I am so sorry to say it depends, but I think it's really going to depend on the youth. Um, and what I guess you think they might be too hasty in making a decision about like, are they going to run off and get married? And do you think that they need assistance in making that decision or not? So I don't really have kind of a rule of thumb, but I wonder if there's some sort of resource online on, some sort of questions. I mean, I think this is where the IEP may be really important, or the last IEP the person had, in terms of that's the document the court uses to help determine what not decision making, but what sorts of things they can do for themselves, especially as they get older and it's more of like a transition plan. So I would maybe take a look at that document to see if it gives me any sort of information as to what may be appropriate and maybe inappropriate. And I would also say, I would ask the alleged ward. I would ask the person, hey, do you think you want any assistance making some of these decisions? I think you'll be surprised by the amount of things that they are okay with getting help on. And of course it's not across the board, but I would also ask them. I mean, we are talking about them. It's sort of like talking about people in the room and thinking they're not in the room. They're probably going to be in the room. They should be in the room for that hearing. So I think it's a great conversation piece to have with that person. And those are all the Q&A questions I have, but I'm going to check the chat now.
Here's a chat. The last chat question is asking about training or resources for relatives, former teachers, etc., to help them understand the responsibilities of a guardian advocate.
My goodness, that is such a great question. I believe that there is, see, I know that when you become the guardian or the guardian advocate, that course you have to take within the 4 months explains to you what the process is. But I have to tell you, Miss Jones, I think we could create it a really easy, I mean, here I am creating more work for myself, but this is really important stuff. I think we could create a really simple presentation that could be utilized for, as you said, like to kind of like pitch the idea of the becoming a guardian advocate. I think that's a great idea. So I'm actually, Miss Jones, if you'd reach out to me separately, I would love to work on this. Um, and yes, of course. Oh, thank you, Brittany. Honestly, I would love to work on it with you because I really think we can make this thorough, but not overly complicated, because you want to be honest with people about what it could entail. But it again, it's not like the person has to live with you. It isn't necessarily what people think that it is. And of course, Janella, I apologize. I can't see the rest of your last name, but yes, please reach out to me about the venue issue. Happy to help on that. And let me make sure and see if there's
Ericka,
anything.
there's a question. What is required for DPOAs, etc., for principals who are non-English speakers?
Now, I have to tell you all, that is a great question. I'll have to look into it because I'm assuming what you're going to have to do is what I would do, and I do speak Spanish, is I likely would have the document in English and then I would have it translated. And that's what I've done when I needed to do, let's say, for example, a letter to a parent who didn't speak English, but it was like it was an official letter and like other people were going to read it. So I actually wrote it in English and then I wrote it in the native language and then I had her sign I had her sign the document and had like both in English and Spanish. Um, so that's how I would handle that. That's a great question. And then if anything, if you need to have something saying it's an official translation, maybe you would have to pay that fee. But I think at least having it in English and the other language, I think would be really helpful. I see in the Q&A there's a question. We still don't have copy of the IEP, but have a psychosocial. Can we file that? Well, according to the statute, it has to be less than 2 years old, but I think it won't hurt to have. Typically, psychosocials don't necessarily change, and neither do IQs, by the way. IQs don't traditionally change. I mean, by six, they consider your IQ to be crystallized, and so I would say if you have that psychosocial, and I hope you get a copy of that IEP soon. And if you have trouble, please let me know. You should not be having trouble getting a copy of the IEP, especially with the standardized system that we have, if it's here in Florida. But I do think I would submit it. I mean, honestly, yes, as a person gets older, they're going to have more abilities. But I think psychosocials have a lot of just background information and will typically include that initial information. It's just to show the person has a developmental disability, right? And then the IEP is going to show what their limitations are. All right, going back into the questions.
Early on, there was a question from Anna Fernandez. If the youth would like to have a caregiver who would be the appointed guardian advocate if approved, in the room or meetings with him and the appointed attorney, since the caregiver is the only person they trust, is this allowed, or would the prospective guardian advocate not be allowed in discussions with the attorney and the youth? And I had answered in the chat that the attorney can and should meet with the child and prospective guardian advocate, but the conversation would not be covered by attorney-client privilege. I don't know if you have any
Correct.
thoughts about that.
No, I 100% agree. And I do believe at some point that attorney is going to take that ward aside, even if it's a quick conversation, but they're going to talk to them privately. Um, I hope that answers the question.
George, I
And
see
then,
a hand up. If you could, George Little, if you could type your
Yeah.
question in the chat or Q&A, Erica can respond.
absolutely, I'm
And
trying.
sometimes
Yep.
people raise their hand. I think it's sometimes inadvertent, but if they have if you have a question, you can drop it in the chat.
All right, nothing in the Q&A. I'm going to go back to the chat. Okay. All right. So,
And for the folks that were asking questions about the APD appeals, either for denial of application or reduction in service, there is a statewide work group of attorneys that are handling those cases. If it's something you're interested in joining, you contact Florida's Children First. I just dropped Erica's contact information in. That work group meets monthly, and everyone's welcome to join.
Eric, I dropped your
I'm
email in the chat, by the way. I was going to include it anyway. In the email that will go out from Zoom, Erica's contact information is there. My contact information is always there as well. So feel free to reach out if you need any of this information.
There is one more
Try,
question in the
yep.
Q&A. Okay.
all right. All right, gotcha. I was just done scrolling through the chat. Let me try. There we go. It has to pop up for me. Here we go. All right. May a petition for guardian advocacy be amended before the hearing? I don't see why not. I have not ever had to do that, but I don't see why that would be an issue. And I can't believe I didn't discuss this, and I apologize for it because now we're, pretty much at the tail end of it. But one of the things I want to mention, because I'm currently experiencing this with a client, please, if there's any way you could have a co-guardian advocate, please get it in place. I have a case going on currently where the guardian advocate is extremely ill, likely will pass away in the next year or so. And now there's sort of this scramble to make sure that the co-guardian advocate is on board. And I understand that part of the issue is when they courts have two people, like a kind of an initial and a backup, and they call them co-guardians. There has to be very specific language in both the petition and in what they call the letters of administration that says that the co-guardians can act independently of each other. Because if you don't do that, then that means they both have to make the decisions all the time, and you may not have both of them available. And so for this particular case, I want the two co-guardians to be able to act independently. They're both parents of this adult, so it's the mother and the father, so I'm not concerned about like some nefarious thing going on between the co-guardians, but it's just to have it in place because if the mother were to pass away, we want to make sure that there is no gap in services or assistance for that adult child that they have. So I should have mentioned that. All right, so do
One
you have
more
any
question
suggestions
in
on
the chat. Do you have any suggestions on how to deal with the notice to next of kin when the father's whereabouts are unknown?
I do not.
I would then just default to the search process that is standard for civil and family law, like the look at an affidavit of diligent search and use those tools.
Yeah, that
As Gloria recommends as well.
I have had courts ask me to file an affidavit of diligence search. Yep, when you cannot find next of kin. Perfect. See, y'all could have taught this. Y'all could have teaching us some stuff. Any final questions before I happily give you back 15 minutes of your day? Oh, I see one more.
So the
Isn't
question
guardian
is, I'm going to read that
advocacy?
aloud.
I see it. Isn't guardian advocacy a confidential proceeding? I don't know if publication would be appropriate. I mean, I think that's a fair point. I'd have to look into it. I'll look into it, but I don't know. Um, Person missing next of kin. I'll look into it, but I'm not. Um, I'm not sure. It's interestingly enough, I see some counties actually publish the cases and like anybody can look it up and you can't pull the pleadings, but you can see it. And then in other circuits, you can't see them at all. So it's interesting. I have seen them on some in kind of a weird way. See something in the Q&A is a parent whose parental rights were no terminated, consider next of kin needed to be notified. No, I would consider them not to be the next of kin to be notified. I would not, but I don't know if Robin, you have a different answer or oh,
No,
Jorge, you would
the
like to answer this one?
termination severs that legal relationship. We know, in fact, often young people continue to have good relationships with parents from whom they were legally terminated. But I think for purpose of checking the box for the statute with notice, the termination would be effective.
So I see this question here in the Q&A. Is assessor guardian advocate form specifically to be filled up with the current guardian advocate's chosen person to take over one current guardian advocate passes away? Successor is not considered active co-guardian, correct? I think those are two separate situations. For guardian advocate, I have not seen a successor guardian process in place. I've only seen the co-guardian. So in my particular case, just because I know the mother and the father in that situation, the father's not going to be an active co-guardian unless and until his wife passes away. But in this, if it's a true successor, yes, a successor would not be considered an active co-guardian. I just don't know that I've seen that under the GA process, and I'm going to add that to my list of questions. Successor versus co-guardian versus co-guardian wants to be successor. I'm telling you folks, if you can have a successor or a co-guardian in place, I see that Ms. Fernandez, please get on it. I know I'm being very morbid and like all that kind of good stuff, but I promise you, um, uh, it it happens, right? Just things like this happen in life. So I think there's a form we saw in the county clerk of courts. Perfect. Perfect, perfect. And again, not all the clerks have them, but if your circuit or local county has them, please feel free to please use them. I think it's such a great does the successor guardian advocate need to take the guardian advocacy course? Yes. assuming that would be only for a co-guardian and the successor having to take it in the event that they become the guardian advocate. So if they are the co-guardian, they do need to take the course. So I've already got the dad on that case. I've already had to be like, hey, just so you know, you're going to be taking an 8-hour course because you're going to become the co-guardian. I do believe the successor doesn't have to take it until the time when they become the guardian. But again, I'm going to look into the successor versus co-guardian advocate because I don't remember that being part of the GA statute. But I could be wrong. And I do find that anything that the guardian advocate statute doesn't really address, they are defaulting. It does default to Chapter 744. So that is possible that that's how it would be. And you know what, Christy? I 100% agree with you. Shout out to all the wonderful advocates out there helping children, new adults. It is a wild ride. I'll say that for sure. All right, so going once, let me see. I don't see anything in the Q&A. I don't see anything else in the chat.
Right. I'm gonna go ahead and drop the CLE code again, just in case anybody missed it. I dropped it a little bit earlier. The CLE code is 2602676, N as in Nancy. So that code is also going to go out in the email. It's going to be in the YouTube description, and you can always email me for the code as well. If you do need a certificate, email me asking me for the certificate. I'll probably reply next week with the certificate because I'll be out for a bit. Make sure to bookmark the link that I will include in the email that has the site where we're keeping all these trainings and all the upcoming ones so you can continue to register. And if you need to find previous trainings, you can easily find them all in one place. So I see a lot of thank yous, Ericka. I
And
think I
we'll
see
see.
somebody asking for the CLE number again, so let me make sure to read it out loud. It's 2602676. A lot of sixes for some reason. That's what the bar gave me. So don't
And we
worry,
will see you.
it will be emailed.
See you next month for a CLE on preserving the record for appeal in dependency cases at our regularly scheduled time. And the week prior to that will be our 2026 legislative update and 5-year retrospective. So put that on your calendar and for June 10th. So thanks everybody.
Drop
Thank you
them
so
in
much,
the
Ericka and Jorge.
Yeah, thank you everybody. See you at the next one. Bye bye.